Hi, I'm Greg Dell, joined by attorney Stephen Jessup, and we're going to talk about disability insurance lawsuits. This is the last stage for a claimant who's already exhausted an appeal if they were required to do an appeal, or if they had an individual disability claim, they could right away file a lawsuit. But usually from our firm's perspective, if someone's hiring us, we almost always do an appeal anyhow because we want to build up, whether it's the administrative record, an ERISA, or if it's going to be a lawsuit, we want to have more evidence. And we also are always trying to look for a remedy to get the quickest path to get a claimant paid. But most of the people watching this video have come to our website and they've been denied and they've exhausted everything and they don't know what to expect now, what's going to happen. So there are two types of claims. There's ERISA, which is the group disability, employer provided benefits, and then there's individual disability. Just by nature of how many policies are sold out there, 90% of the policies are group, 10% of the policies are individual disability, which means you're a doctor, a lawyer, a business professional, you bought your policy from an agent. In those cases, that's a breach of contract. You immediately go to trial, and that's your traditional trial with interrogatories, depositions, discoveries, and you're going to get a jury trial. But in the other types of, which is ERISA, which we'll focus on more now because that is 90% of the claims that we see, and we have other videos and discussions about individual disability. So let's focus right now for these group ERISA disability claims. And from when you first get this final denial letter, let's talk someone through about what's going to happen, what's the process, and then we'll get into what are the potential outcomes. But I want to start a little bit backwards in this particular situation. I want to talk about what is it that we can possibly get through a lawsuit, because a lot of people don't know that.
Yeah, so it's very interesting because a lot of people think that if you file a lawsuit and you win a lawsuit against your insurance company that, you know, I guess lack of term, a payday, right? The judge is going to, you know, go after them, you're going to get damages, you know, you're going to be able to talk to the judge and tell everything that's going on or to the jury, and that the insurance company is going to get punished. You know, people say, you know, whether they've lost their house or, you know, expenses because of medical bills because they couldn't afford it because their benefits were cut off. So they think that there's this idea of them going to be able to become whole again, made by it. But under these employer-provided policies governed by ERISA, the only thing that they're allowed to sue for are unpaid benefits. You know, so if you do prevail in court, the only thing a judge can award you is pay the money owed, and even that's some caveats, you know, depending on policy language, and then put the person back on claim. Like a judge isn't going to award future benefits or say the insurance company won't, you know, be able to mess with you again. So when you're suing, you're just suing basically to get the money that's owed to you and be put back on claim.
So just to really break it down for somebody, if you're handling a claim for someone, you file the lawsuit, you go through to the decision from the judge, and 3 years have gone by. Now that person is, say, 55 and they get paid to 65. Does that mean the insurance company has to pay them the next 10 years?
Not at all. Not at all. It's just a judge basically going and saying, hey, insurance company, I looked at what you did. I disagree. And then more often than not, this standard of arbitrary and capricious, and I think it was unreasonable. You have to put this person back on claim, so pay him money and put him back on claim. At that point, the case is back to the insurance company. And the insurance company just says, all right, we're going to pay you up to date, and more than likely request updated medical records because they haven't gotten them. You know, ever since your final denial, there's no new medical information. So they're going to review those records to see if you're entitled to continued benefits. So there's still a good possibility at some point in that 10 years they could challenge a claim, cut you off again, and you go through the process again. So you win, but you're just back in a, you know, abusive relationship with the insurance company.
Okay, then the other thing that I want people to be aware of is that even if you go through and the judge finds, yes, you're disabled, yes, the insurance company was wrong, if that's something that the judge, which we'll talk about in a minute, if that's something that the judge needs to determine, it could just be that the judge has options. The judge can, number one, remand, which is a very common finding, unfortunately, where the judge says, look, I find there was an error here from the insurance company. I'm sending it back with these instructions, which basically says, you need to reevaluate the claim, which could be a second bite of the apple for the insurance company, which is a win but not a great outcome because the company could review and deny you again right then and there. Usually the remand is if the person was never paid before. But if a person had been paid, say they were on for 2 years and then they got cut off because it was a change of definition or whatever the reason is, usually if you win, and someone had been paid already, the court is going to reinstate the benefits. The idea is the court saying, we're going to put you back in the position that you were in beforehand. So we're putting you back in to get paid again, and now the insurance company take over the claim. There is a little bit of discrepancy as to whether or not the judge goes back to the date in which you filed the lawsuit, or back to the date of when the claim was denied, or fast forward what is usually 18 months to 2 years down the road and says, I'm awarding benefits from today going all the way back to when you were denied. That's a little challenging too, because the judge doesn't necessarily know what's happened over the last 18 months. What if you went back to work? What if you got better? So the judge doesn't know that. So all these things are still in motion, if you win the case. But I wanted to start with that because I like people to know, what are we going for? Because a lot of people think, I'm going to win my lawsuit. A lot of people think, I'm going to win my lawsuit and I'm going to get paid forever. But a lot of people also thought, I'm approved and I'm never, they can't deny me. But they continue to evaluate every day. They consider whether or not you're eligible. So let's go back now. What should someone expect if they've a lawsuit has to be filed? What are the timeframes? What's going on? What's their involvement going to be, if any?
Involvement is very minimal, right? Since there's no live testimony, they're not going to be deposed. The insurance company's done with them. And after a final denial, their administrative record, the claim file closes, so no one can put new information in. You can't get updated medicals. Your insurance company can't get anything new in it. So for the individual, their participation, outside of if they have to go attend a mediation, that's really it. At that point, it's just a lot of motion practice and work of the attorneys, with regards to filing, the various different aspects of the court. And then even when it comes to the litigation, it's really hit or miss or luck of the draw of the judge you get. You're assigned to a judge. You don't pick your judge. I've had some judge, you file a lawsuit and they want the case wrapped up within 6 months, and I've had others that it's like 18 months. Or sometimes you get these quick ones and you file everything, you get motions, dispositive motions in, and the judge takes, in 2 recent situations, almost a full year to review and make a decision on it. So the timeline can vary greatly. I think the important milestones for people is once the lawsuit's filed, I always say about 30 days, the insurance company is going to have a chance to respond by an answer. I always joke it's deny, deny, deny everything we say. And even though it's not 30 days under the law, almost always the defense attorney who's hired is going to say, hey, I just got this. Can I get a brief extension to file the answer? I always say yes because the court's going to grant it, so there's no point to be argumentative. So within 30 days, though, you know who your defense attorney is going to be, and you're going to have some type of reply to your complaint from the insurance company. And I think one of the big things from a realistic standpoint of what to expect is being able to communicate with the client, hey, this is the defense attorney they hired, because all those attorneys have their own way about doing things. So you can kind of give them an idea of timing. And I personally, I prefer, federal courts are going to mandate mediation, and that's simply everyone gets together and tries to figure a resolution through a mediator who goes back and forth between the parties. I try to get mediations set as soon as I can. The deadline, I have one coming up, and our deadline is until the end of February of next year. And we're in September. I have it this week, right? Because I want to see if we can get this done sooner than later for the client. And there's going to be communications and negotiations. So for a judge to make a decision on your case, it could take 12 months, 24 months, maybe from the time of the filing of a lawsuit. But there's always a possibility of a negotiated settlement or a mediation within, say, 6 months of the filing. So it really kind of depends case by case on what the intention is. We file some cases, we know this isn't going to settle. We're planning for the litigation. And other ones, it's more of a, the clients, they're over it. They're just sick of dealing with the insurance companies and they want to be done with it. And that's usually through a negotiated settlement. So I tell people you have to reasonably expect anywhere from 6 month to 24-month timeline, or in some cases, if the judge sides against you and you file an appeal, then who knows how long it's going to necessarily be. So it can vary within that time frame.
I think a good reference point for people is that they should consider that 98% of these cases are going to resolve with a lump sum settlement.
Correct.
And that means without the judge having to render a decision. So that is a That's a good thing for a claimant because there's a level of certainty. It's also to know that we've never had a case, unless the client was a fraud, which we didn't know about when they hired them, where the disability insurance company didn't extend some kind of offer. So that means if we're taking your case, we believe there's going to be money that's going to be offered to you. So that takes out that feeling of hopelessness that people have to say, I'm not going to get anything. Now, I'm not telling you it's going to be 100%, and I'm not telling you it's not going to be 10 cents on the dollar. Now, that's not good, but there's going to be something that's offered. And the reason it's important to consider that is that then it becomes a pure business decision. Because as we started our video talking about what can you get as an outcome, your disability policy has a finite value. So for example, if you're 55 years old and your benefit is $5,000 a month, you're owed $60,000 a year, right? So if you've gone on for 2 years that they haven't paid you and it's $60,000 a year, they owe you $120,000, right? And then if you had another 8 years left at $60,000, you know they owe you $480,000, which is future value. But of course, we know they discount that to what's called present value, which means how much money do I have to give you today to have $480,000 over the next 8 years, which is usually just say, I don't know, 60% of that number. So it comes down a bit. But the bottom line is there's a finite number there. So if the total claim you know is worth $500,000 and the insurance company offers you $250,000, you're making a pure business decision as a client. Do I want to go through a trial now, risk $250,000 to possibly get $500,000? How do you know if you want to do that? Well, you're going to look to us to say, should we move forward? What are our chances of winning? We're never going to tell you move forward. We will tell you here, we think you got a 50% chance of winning. We think 90%. We think you got a 90% chance of losing. They're all over the map based upon the facts and circumstances of the case.
And the caveat of that, going back to what we discussed earlier, in your situation, $120,000 in back. If you win, you're getting the back. You're not even getting the $250 or $5. You have to stay on claim.
Right.
You go back to work. God forbid something happened to you. There's no rights to survivorship, things like that. So it really does become a business decision. And a lot of people, I believe, one of my favorite medias always said is, good mediation is when all parties go away mutually unsatisfied, right? There's always a compromise there, but every single client I can think of, I mean, I'm sure there's an exception, but all of them, at the end of it, they're not generally ecstatic, but they have a sense of this is at least done, they're at peace with it, because it's usually been a multi-year, fight with the insurance company. And they can, at that point, and I always speak to clients and potential, and it's a weird piece of advice I go, but when their claims say, don't take it personal. It's a very personal experience, but don't take it personal and think that they're just targeting you, right? This is what they do to everyone. So if you can kind of step back and understand what they're doing, I find that can help the clients look at it in the same sense of a business decision for them. What's the best case situation for them?
I think another thing I'd want claimants to understand about us. We have probably 14 or 15 lawyers that do nothing but this, more than 50 employees who focus on nothing but disability. We want to see the clients get paid as quick as possible. We have the full resource. I almost look at us as being like a special forces, highly concentrated unit who's ready to go, who will fight them and probably be the best there is in that particular type of area. So these disability insurance companies know that. They know that when we put offers out there, we better put our best offer out there for the claimant, because they're going to go the distance against us. And not only are they not afraid to go the distance, they have the financial resources, they have the time, they have the skill. They're a financially sound law firm. They're not desperate for money. They truly want to do what is in the best interest of the client. There's not a lot of law firms who can say that, because you get a $200,000 offer out there and the lawyer's looking at it and going, oh my gosh, I'm going to make X amount of dollars. I want to settle now because I got to make payroll next week. It's not the way we think here. Here it's about what's going to be best for the client and setting aside whatever the variables are here, because we can do everything we can to help that client to win. So that's something that's really important when you're considering your law firm. Are you putting someone in a position, are you putting yourself in a position with a law firm that's going to get you the top offer without even having to go to trial? And if you do have to go to trial, what kind of lawyer is representing you? Have they been there and done that before? Can they get you the outcome that you need? The benefit, I think, sometimes of ERISA is that if you win your case, the law is that if you have success on the merits, you're going to get an attorney fee provision. You're going to get an attorney fee award.
At the discretion of the court.
At the discretion of the court. But usually if you win and they say you're going to get benefits, it's almost with certainty that you're going to get it. It's not a guarantee because, again, the judge could do something crazy and say, no, we're commanding the highest rates in the country for attorney's fees. What that means for the claimant is that the attorney fee award is likely going to be very substantial, that any contingency fee agreement that you have with our law firm will probably be substantially covered by the amount of that attorney fee award, versus someone else who's not a regular in this type of industry is not going to command the same kind of attorney fee. So a lot of advantages to having a super experienced law firm besides the level of expertise you get in going forward. But if you happen to make it down the line, there is that attorney fee award. There's some lawyers who only want to go to trial because they want to try to get the attorney fee award. We don't do that. We just, whatever the outcome is going to be.
Well, you were saying that, and some people think, well, if I win, I'll get my attorney's fees paid. And it's always at the discretion of the court, but how much, right? So sometimes they think like, oh, you get this as your lawyer, you just want to settle this case because you want to get paid. In our minds, we'll probably get paid a lot more in attorney's fees, but there's a big risk in getting to that point, and what's better for the client, right? So yeah, we actually in settling cases can stand to make much less money because that's the best interest of the client than if it's something we can go prevail on and get attorney's fees on.
You bring up a good point, because I could tell you that, in every case that we have that goes to verdict, the attorney fee award is almost always in excess of 6 figures, which is a fee that would probably in the vast majority of our cases exceed what our normal attorney fee would be. So if we wanted to take every case to trial and try to roll the dice, we'd probably be in a position where we'd be making more money on these cases. But it's not fair to the client, and it's a high risk. We're going to lose the case and go on to the next one. That claimant's going to lose the case, have no money, potentially be exposed to the attorney fees of the defense attorney, possibly. Not always, but it's a risk.
It's probability, possibility, not probable, but always possible.
Right. So, so we touched on what the what you can get from these cases. We talked about time frames as to how long this can take. Although you were talking about how long it takes until you get to a mediation, which is usually, you say, within...
I would say you can expect 6 months out, and then, trial, just judges making decision 24 months. But I think it's important, for people to understand that there are going to be these steps along the way, in the mediation. You brought something up and you said it kind of always thinks of way I look at it with clients. Just like, since all of our clients go to doctors, a doctor can't guarantee you an outcome. Always going to tell you what the risks are. Like, we couldn't guarantee what a judge is going to decide. I mean, I've been this year very surprised by a judge's opinion that we've received on one of our cases. But I can guarantee you that insurance company is going to come to the table and want to discuss numbers, right? And I think that's important. Like you said, these people think they're never going to see anything again. There's always hope. And they'll say, well, why would the insurance company want to settle with me? I think you went into the, some of it, they could be on the hook for attorney's fees. That's extra money out. They did make mistakes. We win cases, things like that. So for the insurance company, they are seeing it as a business. And I think, it's important for the individual to see it that way too, just to help them kind of cope with the situation, because it's tough. It's a very, very highly charged, emotional time.
I want to talk for a little bit just about the technical aspect of what happens after if you don't resolve your case at a mediation, and how the whole motion process is in these ERISA cases. So, as you know, what happens is that the judge is ultimately going to make the decision. There is no jury. And the judge is going to review what you said is the administrative record, which is every single document that was ever submitted, ever relied upon, that ever existed with regard to this case prior to the final denial. Both sides are going to be required to submit briefs, which are basically our documentation arguing all the facts that support disability and the case law that backs that up, telling the judge this is why under the law they acted unreasonably, this is why you need to reverse this denial. They get to submit a brief, we submit a brief, we both may have the opportunity to submit reply briefs. Once the judge has all of the briefs, the judge has to review the record, and then the judge can make a determination as to whether or not the judge is going to allow oral argument. Not required by law, but if there is an oral argument, or the judge may find that we need to have a bench trial, which is a very interesting concept as well, because there's this is getting a little technical, but there's this dispute between whether or not there really could be a summary judgment motion in a lawsuit, or if there should be a bench trial, which would basically be like an oral argument in which one of us would go in and we would argue on behalf of our client the merits of the case, and possibly the judge may say, I need to hear from somebody. Gets into a little bit of wild, wild west there in terms of what's going to happen, but the majority of the time is the judge is going to say, yes, I'll hear oral argument, and then I'm going to make a determination on the papers that are here. And that process is never going to be, I mean, I've never seen it less than 12 months, and on average probably 18 months until you actually get a decision. So, and then if you win that process, you're a minimum, if win or lose, there could be an appeal from either side.
Correct.
That's another year minimum in the process. So you could be looking 2.5, 3 years, you know, if you win, even if you win, and then on an appeal. So that's the process and how that goes. But you would say 90% of the cases are done in 6 to 9 months between reaching a mediation and then finishing at that case. And then the last thing to touch on, and something that we've built I don't want to call it a special relationship, but a working relationship in trying to maximize value for the clients and also insurance companies trying to save the cost of litigation, is what we call these pre-suit resolutions. Can you talk about that for a minute and why that's something kind of unique to our law firm that tremendously benefits claimants?
Yeah, I call it like the sneak preview that you'd see at a movie. It's not the trial, right? So reaching out to the in-house legal departments of the insurance companies, see if they do want to discuss the claim prior to filing a lawsuit. And then, you know, they're going to, you know, the legal departments of your insurance company have never seen your file. So they'll pull the file, they'll do their assessment, they advise. I always joke they advise their clients, they all work for the same company, but the client is the person from the business department that controls settlement amounts and numbers like that. But there's a possibility, without having to file the lawsuit, without risking, you know, judges' decisions, all this type of stuff, the money, you know, filing fees, mediation costs, all that, so you can keep the costs down. And usually quicker. A lot of times those can be, you know, if it's settled with in-house departments, 3 to 4 months, you can have something in. So it's a way to really gauge what the insurance company's temperature is towards it, because at the end of the day, I've had some that didn't settle. We've went on to litigate, and recently I won one of those cases in it. You know, so I knew what their position was. They knew what I mean, generally we know what each other's positions are, but for the most part, I think you can also get a temperature of how the insurance company's viewing your client. You know, if they're being very difficult in pre-suit, they're probably going to be difficult throughout the whole process, right? Because whether they think there's a credibility issue, whatever it may be, but you know, with the in-house departments, you work with them enough, just like outside defense counsel, there's not a lot that do it, that you do build good relationships with and working relationships, and there's a level of trust and professionalism, you know, that gets bestowed on. You know, I don't like to, you know, talk badly of any law firms, but I've had in-house attorneys say, we won't deal with X, Y, and Z firms anymore because we thought they were being dishonest or they were doing this. So, you know, even the weight of the reputation, and be able to, you know, make the calls and see if everything can get done much sooner. And also keep it out of the public record, right? You file a lawsuit, it's in the public record.
That's a big thing too.
And there's a good likelihood of, if you settle your disability case, some years down the road, you may want to try to go back to work. And anyone who does a quick Google search would find that you had a lawsuit against an insurance company for a disability thing. So some people don't want that in the public record as well.
Not having that public record is a very important thing, I think, as well.
Yeah.
So. Thank you for giving this summary. What we always offer for people is a free consultation and review of their denial. So if you've been denied by your disability insurance company, feel free to reach out to Stephen Jessup, myself, any of our disability lawyers. We will always provide you with an immediate free consultation via telephone. And we don't charge any fees or costs unless we win your case. So we look forward to the opportunity to speak with you.